Let's talk about what separates a simple theft from a serious felony. In California, that line can be incredibly fine, and it often boils down to what you were thinking at one specific moment in time. Today, we're going deep, deconstructing the state's burglary laws to see what they really say.
All right, before we jump in, the usual but important disclaimer: this is all for educational purposes. It is absolutely not legal advice. Okay, with that out of the way, let's get into it.
So here's our game plan. We're going to start with first-degree burglary, that's the most serious kind, and it's all about protecting the home. Then we'll break down the basic DNA of any burglary, get into the weeds on what entry actually means, and see how a modern crime like shoplifting fits into the whole picture. And finally, we'll tackle what is arguably the most important piece of the entire puzzle: intent.
Okay, let's start with the big one, first-degree burglary. So why does the law treat this so much more seriously than other burglaries? Well, it's because it involves violating the sanctity of a person's home. That's the one place you're supposed to feel safe, and the law recognizes that an intrusion there creates a much higher risk of a dangerous, violent confrontation.
Penal Code 460 lays it out pretty clearly. Any burglary of an inhabited dwelling house is burglary in the first degree. Now that word right there, inhabited, that is the absolute key. It's the trigger that elevates the crime from a lesser offense to a very serious felony. Now you're probably thinking, okay, inhabited dwelling, that means a house or an apartment with people inside, right? And that's a logical assumption, but it's not quite right. California courts have actually interpreted this term incredibly broadly to protect people's personal spaces, no matter what they look like.
And when I say broadly, I mean broadly. The law is much more focused on the use of a structure, not its physical form. So as courts have found over the years, a home can legally be a tent, an RV, a boat, or even a hotel room. It could be an attached garage. Why? Because the goal of the law isn't just to protect property, it's to protect the peace and safety of a person's residence.
And here's where it gets really interesting. A home is still legally considered inhabited even if no one is physically there. The test, which comes out of cases like People v. Aguilar, is all about intent. Does the resident intend to return? If the answer is yes, it's inhabited. It doesn't matter if they're on a 2-week vacation, staying somewhere else during renovations, or have even been forced out by a disaster.
So, now that we have a handle on what makes a home burglary first degree, let's zoom out. What's the fundamental blueprint for any burglary charge under Penal Code 459? What are the core components a prosecutor absolutely has to prove?
At its core, the law is actually pretty straightforward. There are 2 essential ingredients. Number 1, you have to enter a structure. And number 2, at the exact moment of entry, you have to have the specific intent to commit a theft, or larceny, as the law calls it, or any other felony. That's it. The crime is considered complete the instant those 2 things happen simultaneously.
Okay, so that naturally leads to a huge question. What does entry actually mean? Because I can tell you, it is probably not what you think. California law uses a concept that might surprise you, and it's called the least entry.
And when they say the slightest entry, they really mean it. The courts have said time and time again that the moment any part of your body, or even just a tool you're holding, crosses the outer boundary of a structure, the act of entry is complete. You don't have to kick the door in, you just have to break the plane.
Just look at these examples. They show just how minimal this can be. In a real case, People v. Garcia, just putting a pry bar into a door jamb was enough. Or check this out. From another case, People v. Fila, simply passing a hand through an already open window counted as a completed entry. Your foot crossing the threshold, a finger poking through a window screen, that's it, entry complete.
Okay, hold on. If the least entry is all it takes, you might be thinking, wait a second, doesn't every single person who walks into a store enter it? What stops every petty theft in a Walmart from being a full-blown burglary? Well, that is an excellent question, and the law actually has a very specific answer for it, a special carve-out for shoplifting.
So it all comes down to context. This chart really breaks it down. If you walk into a store during its normal business hours and your plan is to steal something worth less than $950, that's shoplifting, usually a misdemeanor. But, and here's the kicker, if you enter that exact same store after it's closed for the night with the exact same intent, it's not shoplifting anymore. It's second-degree burglary. The time of day and the value of the goods, that's what makes all the difference.
We've talked about where you are, we've talked about how you get in, but now we've saved the most critical, and frankly, the most fascinating element for last, and that is intent. This is the secret ingredient. You can't have a burglary without it, and this is where the law can get truly mind-bending.
This is a super common question, and it makes total sense, right? You can't be guilty of burglarizing a place if you had permission to go in. If a friend invites you over or a store has its doors wide open for business, how can that possibly be an illegal entry?
Well, get this. Legally, that common sense assumption is just wrong. This landmark ruling from way back in 1962 says it all. Your secret criminal intent effectively cancels out any permission you were given to enter. So walking into a Target that's open to the public, or even entering a friend's house after they welcomed you at the door, can become a burglarious entry if you were secretly planning to steal something all along.
So how do prosecutors prove what was in someone's head? Well, since they can't actually read minds, they almost always have to prove intent using circumstantial evidence. And here's a wild little twist from a case called People v. Sparks. Let's say you enter a house with no bad intentions, but after you're inside, you decide to steal something from a bedroom. The act of then entering that specific bedroom to commit the theft can be charged as a brand new burglary of that room.
Okay, we have covered a ton of ground here, a lot of nuance, so let's just zoom out for a second and really lock in the most important takeaways from all of this. So, when you put it all together, from the surprisingly broad definition of what a home is, to the shockingly minimal act needed for an entry, and of course the absolute power of your hidden intent, it's crystal clear. California burglary law is so much more complicated than that simple image we all have of someone in a mask breaking a window at night.
And that leaves us with one final, pretty heavy question to think about. When the crime hinges on a state of mind that can only be guessed from the outside, and the physical act can be as small as a fingertip crossing a line, where does the law truly draw that boundary between a simple bad decision and a life-altering felony?